everyone, to today's presentation being presented by Greenspoon Marder. My name is Ed Brown. I'm a partner here at Greenspoon Marder. I'm co-chair of the International Wealth and Asset Planning Group. We're going to be presenting a discussion on, as we titled it here, asset protection and comprehensive estate planning in today's environment. A long title, but pretty comprehensive. Hopefully you guys all have the outlines in front of you so you can follow along, because we plan on generally following the outline so you can kind of see where we are and what the topics are that are coming up as we go through it. Co-presenting with me today is Andrew Beckel. He is senior counsel here at Greenspoon Marder, also in the International Wealth and Asset Planning Group. And also Eric Kaplan, also senior counsel here at Greenspoon Marder and in the International Wealth and Asset Planning Group. So we all deal with very similar issues, very similar matters on a day-to-day basis, a lot of which will be discussed on today's webinar. So let me, with no further ado, go ahead and turn over to Eric Kaplan to start out the introductory comments.
Thank you, Ed. I think the best place to start would be to give the listener a definition of comprehensive estate plan so they have a better idea of what we do and where we're going with everything involved in our outline. Comprehensive estate planning refers to the marrying of conventional estate planning, which focuses heavily upon what happens upon a client's death, with the lifetime side of the overall estate plan, which focuses heavily on the asset preservation component. The asset preservation component of an overall estate plan is the process of organizing one's assets and affairs in advance so as to protect them against risks to which they otherwise may be subject. To guard against such risks, in most situations, assets will be converted from an unprotected form of ownership, such as direct individual ownership, to a different type of ownership of asset through what is known as an asset protection vehicle. Sometimes this transfer may involve assets being converted from a non-exempt form to an exempt form. Other times, assets can be transferred to an underlying business entity, such as a limited liability company. A limited liability company is often paired with a foreign-sited asset preservation trust in order to maximize the client's asset preservation and estate planning goals. It cannot be emphasized enough that asset preservation planning must take place in advance of a creditor claim or threat of a claim against the client or the client's assets. As asset preservation planning generally involves the transfer of assets from a less protected form to a more protected form, all involved parties, and this includes the attorneys who are drafting the plan, must take great care to avoid establishing a plan at a time when assets are under attack from a creditor. Protecting assets after there are claims or threats of a claim by a creditor can subject the client and the attorney to either civil and/or criminal liability. All involved parties must be cautious to avoid the negative implications that may follow from failing to protect assets in advance when there are creditors who are entitled to remedies under fraudulent transfer, voidable transaction, or other similar statutes. Comprehensive estate planning concepts may be used to protect all forms of assets, whether it's cash, stocks, bonds, business interests, art, antiques, or even real property. So, back to you, Ed.
Thanks, Eric. We'll continue on with part one of the outline then. It's paragraph D, if you are following along, about the emphasis on doing this kind of planning in advance of a creditor situation. And actually the end of our outline gets into the ethical components of planning, but this is really a good place for me to discuss that section of the outline. So let me just talk about the ethical considerations now. Part of the reason for doing your planning in advance of any sort of creditor problem is so that not only the client, but also the attorney who's advising do not run afoul of, as Eric mentioned, the fraudulent transfer rules, or in some states known as the voidable transaction rules, because these allow remedies to the creditor that would not otherwise exist. For example, if there is a fraudulent transfer shown when moving assets into a trust or an underlying entity or some other sort of entity for protection purposes, then the transfers can be unwound, reversed, and forced back to the client where they are again in harm's way of the creditor action. So you don't want to be the attorney who ends up having that result for the client. But also the attorney, again, as Eric mentioned, can also get roped into aiding and abetting and assisting with the fraudulent transfer, which can also create some sort of civil liability to the attorney as well. Actually, two states, to my knowledge, last time I looked, California and Connecticut, actually will treat fraudulent transfers as a misdemeanor. So actually there's a criminal component to engaging in fraudulent transfers in some states. So, I mean, that's rare. Most states don't look at it that way. It's just a civil remedy. But nevertheless, you want to avoid fraudulent transfers. It is a state-by-state determination whether or not there is a fraudulent transfer or avoidable transaction. So if you are not licensed in the state where the client is making transfers from or where the assets exist, you probably want to bring onto the team an advisor who can look at the local law just to make sure that they don't see anything under the case law there that might say that this could be deemed a fraudulent transfer. So it's a good idea to have that team effort approach. Hopefully they'll find that if there's no creditors existing or anticipated or threatened or pending at the time that these transfers are being made, hopefully the counsel looking at the fraudulent transfer rules will determine that you're in the clear. Since there are no existing creditors, you can't be defrauding or hindering or delaying any creditors since none exist at the moment and none are anticipated. But I know there are some, especially in the more recent case law and litigation, plaintiffs are getting more aggressive and their counsels are getting more creative and looking at some of the terms in the fraudulent transfer statutes that make references to you can't make transfers that hinder or delay future creditors. Now, future creditors in the past has always been considered by most commentators to mean, yes, maybe they aren't a creditor yet, but let's say you're a surgeon and you're engaging in a surgery where you have to amputate a patient's leg. And then after you close everything up and the patient is waking up out of being sedated, the physician realizes that they amputated the wrong leg. Well, there's no creditor yet. Nobody's threatening to sue the doctor, but the doctor has enough information to know that he might be expecting a future creditor. So that's the future creditor that most people thought that that's what the statute on fraudulent transfers was really focusing on. But again, with creative attorneys, they're trying to stretch that to say, no, any creditor that ever comes up anytime in the future, ever, if what you did today was designed to potentially prevent them from taking your assets away, that's enough to give them protection under the fraudulent transfer rules and allow them to unwind the structure. So that's why you want to work with the local counsel and make sure that you are comfortable with it not being a fraudulent transfer. Now, if the counsel can't get comfortable to say, no, we think you're in the clear for sure, well, there's certain things that can be done in the design. One idea is that you can actually quantify what the exposure is. If the client has $10 million and they do know that, well, maybe something could happen. This is hard to do with future creditors. But if you could actually quantify saying, well, I don't think it could be anything more than a $2 million judgment or whatever, then you can still transfer, let's say, $7 million into a structure because you still have $3 million outside the structure, which is more than enough to satisfy any possible claims. Now, if you get the plaintiffs that can show that they're talking about future creditors, forever in time, well, there's no way you can quantify that. So another approach is you can also do a carve out in the design of the trust or even in an entity that actually directs the people in control of the assets, like a trustee of a trust, to return assets to the client if in fact a future creditor does successfully argue that they are entitled to the remedies under the fraudulent transfer laws. And then that way you can show much more readily that you were not intending to hinder or delay them because you put in this special carve-out clause saying in that eventuality, then I guess heads you would have won, but tails you break even. You're going to end up with the assets back you're no worse off than if you've done no planning. So that's another strategy. So you just have to be very careful, and you have to really look at the specific facts. Even federal law has rules about clawbacks and being able to get back to the assets. Under bankruptcy law, for example, they have a statute that says if you put assets into a self-settled trust, which is a typical asset protecting trust in that you create a trust and you yourself, creator of the trust, are named as a beneficiary of the trust so you can receive benefits back. That's a self-settled trust. And the bankruptcy law says that if you put assets into a self-settled trust or anything very close to a self-settled trust, then there's a 10-year period that a plaintiff can show that you intended to hinder that creditor, and therefore they can claw it back for 10 more years. So there's a strategy around that. Don't create a self-settled trust. Don't have the client name themselves as a beneficiary of the trust. Name it for spouses and, well, one spouse at a time, and beneficiaries, children, grandchildren, nieces, nephews. And then this way, it's not self-settled trust. Better avoid that federal law, the 10-year clawback. Now, I know some clients aren't real happy with the fact that, well, if I'm not a beneficiary, how am I ever going to benefit from these assets? What if everything I own outside the trust goes belly up and I have no money left? And now I'm, eating cat food with my cat for dinner at night. Then, that is not a very, comforting feeling for the client. So there can be, again, this is all in the strategic design and the skill set of the drafters, but you can put in provisions where certain people can have the authority to, example, appoint assets to certain people, which might include the creator of the trust. That way, it's not a trustee power. As long as it's not the trustee that has the authority to distribute back to the client, it's not a self-settled trust. But if it's a third party, maybe even what we call a protector, which we can maybe touch on later, but that's just another person you can name in the trust who is ideally a non-fiduciary, so different from a trustee. But a protector could be named who can have the authority to appoint assets to certain people, including the settlor, the creator of the trust. And then that way it's not self-settled, but there is a way to get the assets back. Now, again, this is all into the design features, a lot of different ways you can go on this, but you can have it so that that power of appointment, as we call it, by the protector, whoever, can only exercise that power in certain events. If you don't want to make it look like it's already ginned up to go and ready to be triggered at any moment, which might look bad in a court, that looks like you can just snap your fingers and get the assets back through this person who has this power to appoint. Well, you can put in certain events that have to occur first before that power of appointment can be exercised. And usually you would pick things that are typically known as events of independent significance. And even though that's not a well-defined term anywhere that I've ever seen, but some of the clear ones are, let's say you set up the trust for spouse and children. Well, you could put in the trust a provision that says, well, if this protector or power of appointment holder finds out that there's been a divorce and the spouse is no longer in the picture, or the spouse has died, well, those are events of independent significance. Those are things that typically the client doesn't have total control over, can unilaterally trigger at any moment, at least not without going to jail. So if you kill your spouse, for example. So the idea is that there's a limit on when that power can be appointed, can be exercised to appoint the assets back to the client. And therefore, as long as you aren't divorced or the spouse is still living, there is no power to get the assets back. So it's a great design feature you can build in as well. So, I'm getting into really a lot of the finer points, but I just thought that's a great thing about some of these webinars, because it seems like a lot of people just hit the highlights and never get into some of the nitty gritty, which is always the stuff I want to know. So I think these are things that are important to note. And again, you got to work with the right counsel that knows how to work these in the proper way to make sure that they work as intended. So anyhow, those are some ideas. I also want to just mention too, there are some clients that still say, no, I want to be a beneficiary from day one. I want to be eligible to receive benefits from this trust. Well, those are the clients that probably want to do a full-blown foreign trust, meaning that there's no U.S. trustees involved, no U.S. protectors. Assets aren't in an underlying partnership or LLC that the client is controlling in the U.S. They're even to go full boat, not even have assets in the US. For example, have the trust own a nice nest egg of a Swiss bank account where there are significant funds that the client can always rely on if they ever need it. And this way, even if there is a fraudulent transfer successfully argued, and again, I think we can design it where it would be very difficult for a fraudulent transfer to be shown, but nevertheless, if it were to be shown, at least the client's in a nice position where they can't force the assets back. They don't have control of the assets, and a court in the US can't force the assets back because they don't have jurisdiction over the foreign trustee. They don't have jurisdiction over the foreign bank. They can't freeze the account. And so typically in a civil liability situation, the client is in a pretty good position that even if they are deemed to be engaged in a fraudulent transfer at some point, the remedy to call the assets back is kind of an empty remedy. Now, I know the one concern, and I'll stop with this on this section, but the one concern is that, well, if a court believes that you could have gotten those assets back, or you created the situation where you couldn't get those assets back, you could be held in contempt of court because you don't get the assets back and sit in a jail cell until you decide to figure out a way to get those assets back. And I think it's suffice to say that that's so rare that happens. I mean, those are usually egregious cases where trusts are being set up right on the eve of a situation. A Ponzi scheme has been run by the client, where it was just obvious that, they just should not be getting away with this. And it's so many things that we can do to avoid that scenario from existing. So with that, I'm going to hand it on over to Andrew now to maybe talk about some alternatives to using trust for protection.
Thank you. So for some of the reasons that Ed may have laid out, some clients are not always as comfortable with using a trust structure, especially an offshore trust structure, for a variety of reasons. There's the complexity, lack of control, some additional tax filings, which I know Eric will go into a little bit later. So what we're seeing with these clients is they're starting to use alternative structures using things like limited liability companies, limited partnerships, limited liability partnerships, and even in certain circumstances, S corporations. One of the benefits of using a limited liability company, which is kind of the gold standard nowadays, is that it's going to limit the owner's liability risk associated with the assets of that company, while also providing some additional flexibility and control. And we know that limited liability companies exist and are respected in all 50 states. Another thing that can be very beneficial using limited liability companies is using a structure where you can actually isolate risk for different assets in certain LLCs. For example, in a scenario would be having a holding company at the top with different subsidiaries down below it for each different entity. So for example, let's consider a client that may have 4 rental properties. These are purely rental properties. They're not being used for personal use. You could have one company holding interests in subsidiaries at the bottom. Each different rental property would be in 4 separate LLCs, each with its own bank account and each with their own lease agreements, etc., with the tenants. And now let's say one of those companies becomes sued because of a slip and fall accident associated with the property. And let's also assume that the landlord was actually negligent in this matter. So it would be the landlord's going to be negligent. They're actually going to be found at fault by a judgment. But because we have isolated the risk in one LLC, the other rental properties, as well as the client's personal assets, should not be at risk. What will end up happening is there might be a charging order against the holding company, but the holding company does not necessarily have to receive distributions while that charging order is in place. So now what we've done is we've made it so that that one entity and its assets are the only thing that are going to be at risk if a creditor attack occurs. Now, one of the flip sides of having these LLC structures is there are formalities that need to be followed. As I mentioned before, each entity should have its own bank account. If we need to move money between the entities, it has to flow through the proper channels, be approved by the managers or the members as applicable of the right entities. And if these formalities are not followed, there can be risk that a court would, quote unquote, pierce the corporate veil which is a concept that began in corporate law, but is also applicable to other limited liability companies, limited liability partnerships, etc. So it's extremely important that these formalities are followed, because if we don't follow them, begin commingling expenses or transferring funds back and forth without actually going through the proper approval process, it's going to lessen the protection that's offered. But if these formalities are followed, a limited liability structure like this can actually get a lot of the benefits that a trust would, but allow the client to be the manager of the entities, maybe even have voting interest in the LLCs, and get a lot of the protection, although not as full as a trust will. It can get you a lot of the way there. There's also some additional flexibilities with LLCs, because some clients may choose to have an offshore LLC, for example. Nevis is a country that has very beneficial LLC laws, and they do allow for offshore entities that do business in the United States. Some clients have liked to engage in this because you do get some of the benefits now of having an offshore jurisdiction, like you would with a trust, but you still get a lot of the benefits of having an LLC in place with some of the additional flexibility, ability to take distributions, manage the assets, etc. One of the downsides of having an offshore LLC, however, is many of those complexities with filings, etc., that are brought in with an offshore trust are present in offshore LLCs as well. Therefore, what we tend to see a lot of is clients who may have an offshore structure that will have an offshore trust and an offshore LLC in place. And in fact, any of these limited liability structures, while they're very good and beneficial on their own, can be stacked into a trust structure as well, so that you can get the benefits of the trust and the LLC. By combining these type of alternative structures underneath a trust, you can really bolster up the protection that even the trust would offer. Then you'd have to be able to get through the trust and each of the entities before any of the assets can be subject to creditors, etc. So just keep in mind as we're going through this and we're talking about things, that just because, one, there may be an alternative structure or that we discussed, like an LLC structure or domestic versus offshore, we can always layer these on top of each other to provide an even more protective structure than we otherwise would have had. And another thing to keep in mind is, when we're discussing this, is there's some other alternatives as well. You can do exemption planning at the same time you're doing the asset protection planning. So perhaps we make the offshore trust a completed gift trust as compared to the incomplete gift trust. There can be some planning for divorce, etc., by using these. So just kind of keep in mind, these structures are very flexible and have a lot of ability to kind of mold to what the client's needs are, depending on what their actual goals are. And with that, I'm going to pass it back to Eric to go over some of the practical applications of these integrated estate planning structures and these trusts in particular.
Thanks, Andrew. I'm sure all the remaining listeners are thinking, yes, you've given us all this great information, but how does this apply to me and my clients in the real world? So there are many practical applications for comprehensive estate plans, including inheritance protection, with the when coordinated with the estate plans of other family members. A comprehensive estate plan can be very useful in protecting an inheritance that may otherwise be subject to risk when distributed to the beneficiary. For example, it makes little sense for a client who just received an inheritance from a deceased relative to have such inheritance exposed to the risks against which he has otherwise been planning. Next, many countries around the world have what are known as forced heirship statutes that dictate the percentage of an estate that must go to certain heirs, as well as perhaps the timing of such distributions. Comprehensive estate plans have proven quite useful for clients desiring to achieve what is known as testamentary freedom to carry out their dispositive desires as to the ultimate disposition of their properties, irrespective of local laws around the world. Next, it might be important to protect the sale of a business or professional practice. It is not uncommon for persons who sell their business or professional practice to end up having the buyer come back because they did not run the business as well as the seller under whatever theoretical legal theory and try to recoup some of their purchase price. So protecting proceeds of a sale is very important and is a good practical application of using these types of plans. Next, a lot of insurance issues are involved with the practical applications. For example, it could be used as replacement or for liability coverage. A number of physician clients that we have for various reasons who are not required to carry coverage have opted to go bare once a comprehensive estate plan has been implemented. Other physicians, as well as high-profile professionals, have found it advisable to reduce the amount of coverage in place, with the comprehensive estate plan essentially providing self-insurance for them. There are many people out there who believe that having a large insurance policy in place, whether or not it's ever used, might be a magnet for litigation. So using this type of plan can reduce the insurance policy and thereafter discouraging litigation once a potential creditor knows there's really no insurance policy to try and seize upon. Comprehensive estate plans have been used for covering periods of time for whatever reason there's been a lapse in coverage. Also, recognizing that many insurance policies are quite porous with exclusions and exceptions from coverage, and also recognizing that certain insurance companies could itself suffer economic reversals, a comprehensive estate plan can be useful to provide a means of backup insurance coverage. Next, many business people and professionals are often involved with business or investments that are beyond the main scope of their work. This type of plan can afford protection against risks that could otherwise arise from such activities. For example, an architect or surgeon who is a general partner in a real estate investment may be unpleasantly surprised to learn that he or she is 100% liable for all partnership debts of whatever nature. This type of risk may pose a greater problem to the individual than the main scope of their primary activities. Many wealthy individuals believe that just by being wealthy, they're a litigation magnet, so to speak. These types of plans can help reduce such individuals' financial profile to discourage lawsuits. The next practical application pertains to prenuptial agreements. A comprehensive estate plan can be used as an alternative to a prenuptial agreement, and this might be particularly attractive to a client who is on a second, third, or fourth marriage and does not wish to broach the subject with his or her spouse-to-be. Additionally, it can be used as a backup to a prenuptial agreement for those clients who wish to take what is known as a belt and suspenders approach to their premarital planning. And then finally, these plans can be used as protection from future creditors. Somebody who's already suffering from creditor problems, as I explained earlier, while you cannot protect against that because it was not done in advance, you can certainly protect yourself going forward. So this type of plan can be used to help build wealth going forward, realizing that you are not able to protect yourself from anything currently going on presently. Those are the practical applications of a comprehensive estate plan. And now we'll turn it over to Ed, who's going to discuss what asset protection is not.
Thanks, Eric. Yeah, so now we're on page 4 of the outline, if you are following along here on part 3. It's the main 2 points I want to mention here is, which seems to be a misunderstanding by some people, but they seem to think that this offshore asset protection planning involves 2 things. They think that it might involve some sort of tax dodge, and that you're getting out of reporting income to the IRS because you're moving assets offshore and using foreign trustees, blah, blah, blah. And the other, I guess, misunderstanding is they think that when you do set up these sort of offshore entities and trust, that you are somehow hiding the assets by not letting anybody know that you've done this. So let me start with the tax avoidance. These are not designed to be tax avoidance in any way whatsoever. These trusts are typically set up as what are called grantor trusts. And that means that all the income that is earned underneath the trust is to flow right through to the individual creator of the trust personal tax return. So all of it is picked up on the 1040. Nothing is falling off the radar screen with the IRS. And we even send out letters to the clients going in ad nauseum on how these are to be applied and reported for IRS purposes so that they don't, miss that very important note. The second one that I mentioned too is the secrecy aspect. Again, this is not something that relies on it being secret for it to be protective against creditors. In fact, with today's disclosure rules and tax returns that are filed and all that, if you have a foreign bank account, and Eric's going to talk about some of this toward the end, but you'd have to file a report. If you have a foreign bank account to the federal government, you have to report it to the federal government. So there's really no secreting assets and pretending like this never happened. The idea is that everything you've done is above board, fully legal, and therefore it's okay for the creditor or whoever to know that this is what has been set up and when it was set up. And therefore, it is something that it doesn't matter if they know, the assets are still protected. In fact, we've even had situations where clients have actually disclosed what they've done in the midst of negotiations with a creditor. And then the creditor and their counsel start looking at this and saying, well, gosh, we don't want to also bring another lawsuit off in the South Pacific or the Caribbean. And now legal fees are getting expensive and you can't take cases on under contingency fee basis in some of these foreign countries. So all of a sudden, negotiation and compromise of what is going to be paid to the plaintiff to make them go away become a real conversation. And the client ends up actually doing much better. So those are the main points I wanted to mention on that. And now I guess we'll proceed on to part 4 here on planning techniques, which Andrew will address.
Thank you, Ed. We're going to kind of go into some of the aspects of the trust as the planning technique. This is a fairly lengthy portion of the outline, so I'm going to try to hit some of the highlights in it for you, but make sure to kind of look through some of the more detailed discussions, particularly with some of the foreign tax issues that may arise, because those are important, but it's simply not going to have time to make sure we can get through everything in there. So to kind of start off, I want to just go over some general comments about these trusts and some of their structures to kind of tee up some of the things we're going to discuss later. Something to note is there are lots of different types of structures for these asset protection trusts. There can be the offshore trust, which is kind of the traditional one that's been used for several decades now. Some of the common jurisdictions that are used in that currently, Cook Islands, Nevis. There used to be a lot in the Isle of Man or Jersey or Guernsey, but we're starting to see a lot of the South Pacific and the Caribbean being areas where they're used a lot. But more recently, you're starting to see a lot of US jurisdictions also have self-settled asset protection trusts. Some of the main jurisdictions that you hear about are Delaware, Wyoming, Nevada, South Dakota, but there are certainly others that have beneficial laws as well, such as Ohio, and more states are starting to pass them. What this means is if you have a specific client who is not interested in going offshore and lives in a state that may have a self-settled trust statute, you can use that state statute to do a self-settled domestic asset protection trust. Or if you have a client in an area where there is no self-settled asset protection trust statute, you may be able to still utilize a separate state's statute. However, one thing to always keep in mind in all of these planning techniques we're talking about is some of the trade-offs that occur. So if you want to have a domestic trust as compared to an offshore trust, there's going to be the trade-off in that you're not going to have some of the complexity of the offshore trust, but you may have some issues that arise because you're using a domestic trust. For example, there is the full faith and credit clause in the Constitution, where the states are supposed to give full faith and credit to judgments of other states, etc. So if you have a client who lives in a non-self-settled asset protection state, let's say like California, and they have a Nevada trust, they're sued in California, found liable. Now someone can take that judgment to Nevada and try to use it to get after the trust assets, California may say that the trusts don't protect against creditors. Nevada does. Now you have a kind of conflict of laws. Which state is going to win out? That could depend on a case-by-case basis, certain facts, but that is something that you do not need to deal with an offshore trust. There's also the supremacy clause of the United States. So just because you are using an onshore structure in a state that specifically allows these types of trusts, if it is a federal law matter, such as bankruptcy, the federal law may ultimately trump what the state law says due to preemption. And now you're going to have an issue where you have a trust that otherwise would have been very protective, but because you filed for bankruptcy, the trust now may essentially be worthless. So these are some things that you have to kind of look at the trade-offs, where you do have some benefits of having an onshore trust versus an offshore in some of the tax filings, etc. But it may ultimately not be as protective as an offshore trust. And now, what are some of the advantages of these foreign trusts? Like, why would you use one, and what are those benefits that help with these trade-offs? Well, specifically with the offshore trust, you're usually able to retain some more control and be a beneficiary of the trust and have a beneficial interest. Some of the US trusts are starting to take on some of these aspects, but generally some of these offshore jurisdictions have much better spendthrift protection than even is offered in the United States that can allow it to be clear that the settlor can in fact be a beneficiary, or that the settlor may be able to serve a certain role, such as the protector. There's also the fact that these offshore trusts are less likely to be automatically named as a party to litigation. Again, there's offshore trustees involved, jurisdictional issues involved, things like that, that just kind of make going after the trust, particularly at the onset in the litigation, a little bit more difficult. But one of the biggest benefits that these offshore trusts are going to offer is the fact that you now have multiple jurisdictions in place, all of which laws are going to start to become applicable. That's going to put up a lot of roadblocks. So let's say you have a California court that has a judgment against the settlor of the trust. Now they have to take that actual judgment and enforce it in the Cook Islands. That means they're going to have to go to the Cook Islands, find a lawyer in the Cook Islands to do it, and get the court in a jurisdiction that has a strong public policy to allow these asset protection trusts to actually allow the judgment to be held against the trust and get to the trust assets. This is going to be an extremely difficult proposition for any litigant to make, as Ed had brought up, but some of the other reasons why may be the statute of limitations for that particular claim or a fraudulent transfer may have already run in the Cook Islands because it may be different than what's in the United States. Burdens of proof can be different depending on the ultimate claims. So that may mean that just because you met the burden in the US, you may not meet the burden in the Cook Islands. And you're going to have this, again, as I mentioned, the strong public policy against allowing these types of claims. Because of that strong public policy, the courts are going to be reluctant in most circumstances to enforce the judgment against the trust. Otherwise, the overall laws of that jurisdiction are not going to be viewed as beneficial. And the public policy, again, is to allow these types of trusts to exist. So what you're going to find is that these are some roadblocks that are ultimately going to lead the creditor to more likely than not settle, and oftentimes settle for significantly less than you would have settled for if the trust was not in existence. So that's some of the kind of big benefits of having these offshore trusts as compared to an onshore trust, is that it's just going to be much, much more difficult, and there's a lot less sure result if they actually have to domesticate this as compared to the United States. So now that we know that you're going to go to a foreign trust, what are some of the things that you should be looking out for? Well, you're going to need to pick a foreign trustee for one. So now where are you going to pick a foreign trustee? What jurisdiction are you going to use? Well, some of the things you want to consider are the fact that you want to pick a jurisdiction that has favorable and protective laws. So I've already mentioned some of the jurisdictions that are common, like the Cook Islands, Nevis, and some of the ones people used to use a lot, like Isle of Man, Guernsey, Jersey, etc. You also want to go to a place that has a stable political scene and economy, etc. This is one of the reasons why certain jurisdictions are extremely popular. For example, the Cook Islands is actually part of the country of New Zealand. Even though it has some self-governing laws, that means it's part of a very stable, secure country. It's not going to be likely to have any major changes in government, major changes of laws, etc. You also want to choose a jurisdiction where there's not going to be any foreign tax issues. I will touch on some US tax issues, as Ed already touched on earlier, but you don't want to move a trust to a jurisdiction that now is going to subject that trust itself to local taxes, because we want to keep these trusts tax neutral and kind of keep not incur additional tax. One of the most important factors we consider is that there are quality professional services available. You would like to have some trust companies that are respected, have been in business for a while, are easy to do business with, etc. Just because a jurisdiction may have good trust law does not necessarily mean it's a good jurisdiction for an asset protection trust. So that's something very important to look at. And you want to make sure you're also very comfortable with the trustee you choose, that they can be responsive, etc. Because there are going to be, if it's in the South Pacific, which side of the international date line is it on? What's the time of the time zone they're in? Those type of things can sometimes cause some complications. So you also want to make sure that you're with a trustee you're comfortable with and that they'll be responsive. So now that we've picked the jurisdiction, and now that we've kind of looked into where it's going to be, it's time to also look at what are some of the other benefits beyond just creditor protection that these trusts can offer. And this can apply to both domestic and foreign trusts, but really kind of the gold standard in this is foreign trusts. And there are some extra benefits that they may offer as well. So some of the things that these trusts offer is they can actually serve a very similar role to the more traditional revocable trust that many of the clients may have. This can include things like probate avoidance. It can include things like a vehicle for investing, etc. But one of the benefits of the offshore trust is these may actually offer more confidentiality, because you're in an offshore jurisdiction. You're going to have an offshore trustee. They're going to have some laws that will limit disclosures that need to be made. So now you can have a trust that you're not hiding assets, but it is more confidential. It's not going to have your name out there, readily searchable for, like, say, in property records if you have a property owned through the trust, etc. Can also serve as a good vehicle for global investing, as getting bank accounts and everything, foreign bank accounts, it gets more and more difficult every year as continued laws keep getting passed, like FATCA, etc. It may actually help a US person with an offshore trust now may be able to get into an investment that the US person could not have gotten into because they have a foreign component. These trusts can offer a lot of flexibility. As I said, they're not as flexible as a revocable trust, but they can actually have a lot of flexibility. We have some ability to kind of customize the trust and change it as circumstances change going forward, much more so than you may have if you did a traditional irrevocable trust in the United States. And lastly, as I will also touch on a little bit later in this part, these vehicles can serve as a good vehicle for exemption planning. That would be a little bit different overall structure for the trust, but these can be very beneficial for clients in the exemption planning side when they may want to use up their current high exemption, $12.92 million per person, but maybe they're concerned about giving up such a significant percentage of their wealth, because with the exemptions as high as they are, a lot of people that might be worth the $25–30 million range want to use up that exemption, reduce their estate taxes, but they're going to be left with very little assets afterwards for their own personal benefit to do so. Well, these trusts may actually be a vehicle that they can use to kind of meet both their needs. All right, so now that we've kind of gone through some of those benefits, the foreign versus domestic, I want to briefly touch on something I mentioned earlier when I was talking about the LLCs, is combining the various different approaches. you can do this by having, an offshore trustee can own, or offshore trust can own a domestic LLC or a domestic LLC holding company structure, so that you can kind of get the benefits of the LLC. Client may be able to serve as the manager of the LLC, kind of still involved in the day-to-day business of those particular companies, can have the, isolate the risk like we discussed earlier, but then have that underneath the umbrella of an offshore trust, so that now, let's say that a court does allow piercing of the veil of the underlying LLCs. Well, now they have those LLCs, and now they have to move it to the Cook Islands or Nevis or wherever the trust may be to actually get that judgment enforced against the trust assets. So just because they've gone through the LLC, they still need to figure out a way to get to the trust to get at those assets. And that's going to make the entire process extremely more difficult for the creditor, because there's, again, piercing the veil can be a high bar already. Well, once you clear that high bar, you still need to clear the high bar of going to a jurisdiction that may be potentially hostile to enforcing these types of actions. Another benefit that you can have with some of those LLC structures underneath is perhaps you have a holding company in a state like Delaware, and then for your rent in a local LLC where, say, each of your actual local rental properties in the example I used earlier are located. Now you're bringing in multiple state jurisdictions. You're going to have multiple state laws, as well as an offshore jurisdiction. These are a lot of different laws, a lot of different things for the creditor to kind of weave through, making the litigation to actually enforce a judgment extremely complex. They're going to have to pierce the veil, multiple different jurisdictions, get it enforced. So the more we can bring up in these jurisdictional differences, the better and more likely it is that a creditor is going to settle, possibly even for pennies on the dollar, just because of this added complexity. But one note, if it is an offshore trust, it's not typically a good vehicle for S corporations. There are some alternative structures where we can have a foreign component but be domestic for tax purposes, which may allow an S corporation to be held by the trust. But if it ever converts to a foreign trust for any reason, that may blow the S election, which would then convert the S corporation to a C corporation, and that would likely be a negative or a negative outcome for the client. So we should be extremely careful if we have S corporations involved on whether or not we're going to put them into the structure, or whether maybe a domestic structure would be a better idea for them, because those don't have some of the same risks with S corporations. So the last things I'm going to talk about now is some of the tax implications. Eric will get a little bit more into some of the tax filings and the forms that need to be filed. But needless to say, if you have an offshore component, it is going to be an extremely complex set of tax filings that can have some big penalties if you don't do it properly. So, as Ed mentioned, these trusts are set up to be tax neutral. He talked a lot about the income tax side of things. It's going to be considered, in most cases, a grantor trust, at least during the lifetime of the settlor. But it also is tax neutral for gift and estate tax purposes, generally. That means we're going to have an incomplete gift trust when they're transferring it. So the settlor is going to be a beneficiary. They're likely going to have either a limited power of appointment or some other type of aspect that's going to cause this to become an incomplete gift. So that means all the assets will be included in the grantor's estate for estate tax purposes. Therefore, it is a completely tax neutral vehicle for both gift and estate and income tax purposes. Now, it is possible to potentially set up an offshore trust as a non-grantor trust. However, if there's any U.S. beneficiary during the settlor's lifetime, it will be a grantor trust. So it is extremely difficult to set up a non-grantor offshore trust, but it may be possible to do so in an onshore trust. A lot of people may have heard of things like NINGs and WINGs and DINGs. These are some types of non-grantor self-settled trusts that kind of use those asset protection statutes of local jurisdictions, but that becomes very difficult to near impossible to use in an offshore jurisdiction. Also note that the trust may be a grantor trust during the settler's lifetime, but once the settler passes away, these can become foreign non-grantor trusts, which can have some income tax applications or implications that need to be addressed. For example, there's throwback taxes when distributions may be made to beneficiaries of an offshore non-grantor trust if they're U.S. persons. There can be some risk that there could be some realization events upon death, although the IRS has generally held that just because the grantor died, that's not going to be the case. But we should be aware that if you do have a foreign trust that is a grantor trust in the settler's lifetime, when it becomes a non-grantor trust upon the settler's death, that can be potentially problematic. The last thing I would like to point out in this section is going to be that, as I mentioned, these are also estate and gift tax neutral, but then I said we can use these for exemption planning. So there is some ways to set up a self-settled asset protection completed gift trust. It's going to be much more complicated, and it's going to not have some of the same flexibility that we have for a incomplete gift trust. And necessarily because some of those flexibility that we build into those trusts would actually cause the trust to become an incomplete gift. However, we can do that, and this is beneficial for those clients that want to use up their high exemption before it goes back down to prior levels after 2025, but may not feel comfortable giving up such a large percentage of their assets. So if that's a client that you have that maybe they're worth $30 million and they want to use up their exemption, but they're worried about only having essentially $5 million or less left over for the rest of their lives for them to use, an offshore self-settled asset protection trust that is designed as a completed gift or a domestic trust could be a good vehicle because it would allow you to use up their exemption, be a completed gift, but the settler can retain some beneficial interest. Just to always be aware that if a distribution is made back to the grantor, they're not getting their exemption back. So that would be some wasted exemption. So hopefully we can at least limit those, but it is a nice vehicle. And the last thing I also want to, so one last thing I did want to point out is that, I'm talking a lot about offshore trusts versus domestic trusts, etc. But there is also a way that you can have the offshore component for creditor protection purposes, but have the trust treated as a U.S. trust for tax purposes. This has actually been a very popular way for a lot of clients to set these up because they can get the benefits of having an offshore creditor protection trust while not having to necessarily deal with some of the complexities about having an offshore trust in place. In these cases, there would be a U.S. person as the trustee and the protector, which could reduce the asset protection offered at least to somewhat of a degree, but many clients seem to think that this is a valid trade-off. And with that, I'm going to pass it back to Ed to go over whether foreign situs asset protection trusts actually work, and we can keep moving on.
All right, thanks, Andrew. Here, we're now on part 5 of the outline. Do these trusts really work for protection purposes? And if you scroll through that part of the outline, you'll see that, first of all, we talk about in the absence of any planning at all, yes, these do work very well when you compare what the end result would be with and without the planning. It's not that our clients that set up these structures all of a sudden are in a situation where nobody will ever sue them again, or as soon as the plaintiff finds out that this planning has been done, the plaintiff just says, oh, well, never mind, and runs in the opposite direction with their tail between their legs. That isn't really how that works out. But instead, as I kind of mentioned earlier, it brings negotiation of a settlement to the table more quickly, and possibly could avoid the cost of going actually through litigation itself, and then getting this thing settled, looking at the hazards of litigation and really what are the chances that even if the creditor were to win a lawsuit, as far as a court judgment comes down the pike at some point, it's a whole nother thing to collect on the judgment. So it's a big empty victory to get the judgment and then not be able to collect a dime. So usually negotiation is brought to the table when they know that this planning has been done. So in our experience over 20 plus years, the clients have typically fared much better as far as what they ultimately had to pay for the creditor to go away as compared to what they would have paid if they had had a bunch of low-hanging fruit there for the easy taking by the plaintiff. So if you, interest of time, if you just scroll through the details of the outline, I really go into numerous cases, not only cases where it worked to set up these types of structures, but also planning where it did not work. And you'll see from the facts that we give in the outline why they did not work. Obviously, they were situations that were clearly fraudulent transfers, or a person putting assets into the trust had stolen the assets in the first place and really never owned the assets. And we even give some client examples of where we've had the clients come out much better and sort of some details on that. So I'll just leave that for your reading pleasure in the future, and I'll give it back to Eric so he can talk about the tax compliance side.
Thanks, Ed. In the interest of time, I am only going to cover the more basic tax filings that need to be considered for a comprehensive estate plan. The outline, and this is part 6 of your outline, contains a lot of different forms and form numbers, but I'm just going to cover the 5 of the basic ones. First is the Form 1041, which is the U.S. income tax return for trusts and estates. A partially completed Form 1041 needs to be filed, generally speaking, by April 15th. Now, as Ed alluded to earlier, a trust that is designed where the client names himself or herself as a beneficiary is known as a grantor trust. When a trust is classified as a grantor trust for federal income tax purposes, the individual creating the trust, otherwise known as the settlor, is taxed on all the trust's items of income, deduction, and credit, as though those persons were the owners of the trust assets for federal income tax purposes. Now, your Form 1041 will reflect the trust status as a grantor trust for federal income tax purposes, and will have attached to it a simple list of items of income, deduction, and credit that will be reported on the trust settlor's individual income tax return, which is Form 1040. A similar form will likely be required in the state in which the settlor lives, depending on local law. Next, if a foreign or offshore trust has as one of its assets an underlying limited partnership or a limited liability company, IRS Form 1065 U.S. return of partnership income will be required to be filed. Now, generally speaking, limited liability companies are taxed as partnerships unless they otherwise elect to be treated as a disregarded entity for income tax purposes when they're created. Therefore, for all LLCs that are treated or taxed as partnerships, these LLCs will also have to file Form 1065. Partnership K1s will also need to be prepared as part of the Form 1065 for each partner of a limited partnership and member of an LLC. In a typical structure, a 1% K1 will be prepared for the general partner of a partnership, which is typically the client, and a 99% K1 will be created for the limited partner of a partnership, which is generally the offshore trust. Next is IRS Form 1040, as most people are used to seeing, the U.S. individual income tax return. The trust settlor will file Form 1041 as usual, noting the items of income, gain, and loss reflected on the list that's attached to the Form 1041 and on the K1s that are to be received from the limited partnership or limited liability company. The next 2 forms that I'm going to discuss are very important when dealing with foreign trusts for federal income tax purposes. Now, a discussion of what a foreign trust is for federal income tax purposes is beyond the scope of this discussion. But if you take nothing else away from this section of the outline, if you think you're dealing with a foreign trust, make sure to get with your CPA, accountant, financial advisor, or even attorney to make sure that these filings are necessary due to the fact that the penalties imposed can be substantial. The first form is IRS 3520A, which is titled Annual Information Return of a Foreign Trust with a U.S. Owner. If a U.S. person is the grantor of a foreign grantor trust and is treated as the owner of such trust assets based upon Code Section 679, he or she must ensure that the trustees form IRS 3520A, generally speaking, by March 15th of the year following the trust immediately preceding tax year. Substantial penalties can be imposed if IRS Form 3520A is filed late or is incompletely filed. Now, the potential penalties involved here are the greater of $10,000 or 5% of the value of the trust assets as owned by the U.S. person. So as you can see, getting this particular form right is of utmost importance. The next form I'm going to discuss is IRS 3520, the annual return to report transactions with foreign trusts and receipt of certain foreign gifts. A U.S. grantor of a foreign grantor trust is required to file Form 3520 on an annual basis. And this must be filed even if the grantor neither made a transfer to nor received a distribution from the foreign trust. Form 3520 is filed separately at a different location than the individual's Form 1040 and is not attached to the U.S. grantor's Form 1040 for such year. Now, the penalties for not filing Form 3520 are even more substantial, and that would be the greater of $10,000 or 35% of the value of the trust assets transferred to the foreign trust. Even if Form 3520 is timely filed, the foregoing penalties can still be applied to any unreported or underreported income. So if you take nothing else away from this, you have to understand that these penalties are extremely substantial, and you need to make sure you're doing this properly to avoid potential mess. Now, finally, I'd like to discuss what is commonly known as the FBAR form. It's the Report of Foreign Bank and Foreign Financial Account form. This must be completed and filed electronically with the Treasury Department by April 15th of each year, unless it's extended to October 15th. And the individuals who must file such return are persons who have what is known as a financial interest in or signature authority over bank securities or other financial accounts in a foreign country, the value of which exceeded $10,000 at any time during the previous calendar year. This filing requirement can pertain to a trust or to any individual who has such an interest in or authority over such foreign account. There may be multiple filers for a single account. Failure to file the FBAR in a timely fashion may result in the imposition of civil and/or criminal penalties. So again, as I've been trying to hammer home, make sure you discuss these forms with your CPA, financial advisor, or attorney to make sure they're all properly filed. And these are the basic tax filings to consider. There are others in the outline that are listed, and please make sure that you are well versed in all of them, as you want to avoid penalties as much as possible, of course. Now I'm just going to send it back to Ed.
Thanks, Eric. As that brings us to the final portion, the ethical considerations in part 7. Even though I had already accelerated that to part 1, so we really already went over the ethical portion of everything. I just want to emphasize just 2 things just quickly. One is, if you are doing just regular estate planning for a client, you should let them know that, for example, a garden variety revocable living trust, for example, does not provide any asset protection. And because clients don't know what to ask, and that you need to at least document for your file that you at least told them that their estate planning, even though it does certain things that the client wants to accomplish, doesn't do everything, and that they could, if they want to enhance what they're doing a little bit, they could add more to their trust to make them protective as well. I just think it's a good thing to note the files. So you can at least show that the client declined to go that extra yard, so they don't claim that you should have told them that earlier. And then the last thing I want to mention is that if you do decide to do the asset protection planning with the client and you aren't well versed in doing that planning, you really should co-counsel with someone that does do this on a day-to-day basis. I mean, it's right there in the rules of professional conduct. You know, the first rule there, 1.1, the rule of competency, that suggests that you always co-counsel with someone that is in an area that maybe the lead attorney is not well versed in. So just to, again, to avoid any sort of ethical issues there. on the competency side. So that's really it. That wraps it up. Appreciate all of your attention, and I hope you all have a great day. Thanks so much.